Good morning again and welcome. Thanks for being with us. We are excited to continue our Counselor Connect Spotlight on Legal series. Today, we are joined by Andrew Manna. He is going to be talking to us a little bit about counseling notes and education records, and he may have more of an introduction as he gets started here. But Andrew, I'm going to go ahead and hand it off to you so that you can begin.
All right, good morning. You can hear me okay?
I can hear you okay.
All right, well, thanks. I know we've got people still joining, but we'll do a little bit of a rolling start here. Good morning. Andrew Manna from Church Hill and Antrim, and we do have the recording live up and running. So thanks all for joining. As we get started, our law firm has a lot of information with respect to educational records. This is certainly a very nuanced area. Some might find it boring, but I really enjoyed the topic actually. And, every once in a while, I think it'll come up for one of you in your roles, whatever your capacity might be, whether that's a counselor, whether it's another administrative role. It may only hit once a semester or once a year, or sometimes for some of you, not at all. But there is some really kind of nerdy academic explanations that I will get into about records and the nuances of the law. But again, I hope maybe that one nugget of information, that's always my goal in all presentations, that we get something across maybe that you didn't know before. So Amanda is going to help me with advancing the slides. We had a little tech issue, but I'll prompt you, Amanda, so I'm ready for the next one. That's just the picture there, and we'll go to the third slide. So as we start talking about today's agenda and purpose, the Family Education and Rights Privacy Act, FERPA, in the news probably the last few days when you've listened to media reports, etc., about ICE and immigration enforcement. We'll kind of blend that and I'll comment on that topic. Education records and personally identifiable information with respect to the definition of those terms under the law. And then we'll try to do some hypotheticals, some FAQs and scenarios to test your knowledge. I'm a former middle school teacher myself, so I like to do a little bit of a pop quiz here at the end. So next, Amanda. I mentioned when I talked about the purpose, this is a federal law, FERPA. I'll go to the next one. Yep, right there. We don't necessarily expect although there's lots of federal changes happening and underway, that we don't necessarily expect any impact or touch on FERPA, although the last few years, it's certainly been mentioned that, there are some updates to FERPA with respect to storage and technology and how all these things interact with our education jobs and school jobs with respect to storage. So in the future, yes, maybe we might have something that hits, and we'll look to watch out for that. But there's always a lot going on, of course, under the federal changes, under the state changes, and we want to just kind of stay abreast. Although I'll teach you and try to get across as much information as I can today, always check in with administration or your local attorney, or if it's somebody from my office, because there are very fact-specific regulations when it comes to educational records, counseling notes, and I will certainly give you as much as I can today. So next. Those are just joining on. I'm asking Amanda to help me with advancing the slides. So you're going to hear the next prompt quite a bit today. FERPA, federal law, and we're just doing the basic ramp up here. It applies to all schools receiving federal funding. I know we've had some news stories over the last 24 hours about federal grants. And if you haven't paid attention to that, the update information as of yesterday, late afternoon and this morning, is that all our school federal grants are not impacted. So don't worry about school funding, unless we ever have some violations of FERPA, which could lead to denial of federal funding. Next. FERPA's dual purpose. And again, I mentioned this is, going to be a little bit in the weeds for those that kind of like the intellectual part of your job or the law. You're going to hear a little bit of that today. So it'll allow parents the right to inspect and review education records. And again, here in just a moment, I'll try to help explain and define what we mean by education records because there is a formal definition. And in certain circumstances, the second purpose of FERPA is to give us confidentiality for students and parents that we don't release records without the written consent of parents or eligible students. So those are the dual purposes of FERPA. We'll go next. Education records. What is a protected record? Well, again, education records and the personally identifiable information, the PII is the acronym you might hear sometimes. Just to clarify one footnote or note for yourself on this slide, sometimes we hear information about FERPA. You also, of course, in the medical world, hear about HIPAA, the Health Protection Act. We do not apply HIPAA in schools. So even though we might have some nurses information or medical information that's often provided at schools, HIPAA does not apply because we are not a medical provider. FERPA, in all instances, guides us in terms of records that we have at school. The exception to that, just again, a nerdy kind of footnote here, is if we have an outside nurses agency or an outside doctor's agency, and they truly are a medical provider, which we are not as a school, then they might have some HIPAA responsibilities. But for the most part, 99% of the time, we are guided by FERPA in terms of our records and what we have to control. Next. All right, now we start to go a little bit further. So any record of information that is directly related to, and this is where, again, kind of helps you get a little bit further understanding and learning, directly related to a student and maintained by the school. I'll get into this in a little bit later, but the maintained by the school is certainly the update. FERPA as the law has not stayed up with the changes in the technology. And so the maintenance or the storage, certainly the traditional mode used to be a paper file of a student. And now with all the technology and the apps and the software programs we have for student records. So there's a wide array of things that might be, I always talk about, we can't just go check the file cabinet anymore. We have to kind of look beyond to see what's directly related to a student and maintained by the school. Examples could be, disciplinary, attendance. Sometimes those are even stored in different electronic files. Evaluations, student grades, again, depending on your school district and your student that we're talking about, could be stored in a variety of different capacities related to emails. And we're going to touch on that and come back to that at least a couple of times today, that emails and text messages even that contain information about a student. And often when I give trainings for back to school in August with new teachers, reminding them that really anything that's personally identifiable for a student in an email, in a text message, could be considered a student record, even if it's on a personal device. And I'm going to hit that a couple times today. So please, I'm very open to taking questions as we go. So Amanda, I don't know if you can help me watch too. If one pops up in the chat, I'll try to weave in an answer as we go. So next, records that are not education records. And I'm going to pause here for a little bit of emphasis. And again, we're going to definitely talk about protections of counselor records. I'm assuming we have counselors on today along with other types of individuals, but records kept in the sole possession of you, the maker, the individual that has created that document, whether it's notes that's used for your own personal memory aid, your own personal, taking notes. Those are not maintained and not considered educational records. So I bolded that bullet point again, hoping that at least one thing today gets across in terms of our presentation for you all. And I think that what I want to emphasize there is that it's a sole possession of you, the creator. Now, that doesn't necessarily mean that we might not need that note. Maybe you took a note and it takes down some information that we're all going to need at some point. So it's even though it's not an educational record, meaning it wouldn't have to be disclosed under a student records request, it still might be something that we need as a school district, or your administration needs, or your principal, or your school attorney. So keeping in mind that when you get a request for educational records, if they've been kept solely with you, then they are not considered under FERPA. A lot of people kind of miss that. So, I wouldn't get in a fight with your principal, your superintendent, or your administration if somebody says, "Give me all your notes." Well, we learned in this training today that those are not educational records. Certainly they're not, but again, maybe having that conversation, trying to draw that distinction. If they're not an educational record, we don't necessarily have to disclose them. Okay. So keep that in mind, come back to it. Abby, thanks. You just posted, and I think you said, what if it's kept with me, but also shared with parents? As soon as you share it, then it's going to become an educational record. So, that means we're doing more with it than just keeping it for your own personal reason. So if you share it beyond yourself, then yes, it then gets tagged with becoming an educational record. Also keep in mind records that are not education records, grades on peer-and-peer grading, student records created or received by a school after the individual is no longer a student. All of these things are not educational records. But again, it gets a little murky when you're getting a request and trying to figure that out. Certainly, going back to this training, checking with somebody just to make sure. Next. All right. Again, I'm going to emphasize a couple of times that we're kind of get into the academic nerdy part of records. What is personally identifiable information? One of the emphasis points on this slide, again, anything that is their name, their initials, that is a reference to the student. The big one that I emphasize when I do back to school training is anything that could be linked specifically to the student. So when I do back to school training for new teachers, I often say, social media, be careful if you're going in and using, social media, Twitter, X, Facebook, Snapchat, and, you're using it in your school. You got to be careful that anything linked to a specific student is considered personally identifiable information. Here's an example. Somebody posts on your social media, "I had a rough day at school today. The student, got in a fight and got disciplined, and I had to take them to the principal's office." Well, by just, describing that fight, if a lot of people already know in the community, or if it's a small community and they know the identity of who is involved, by you posting that description, it's personally identifiable information. Even though you didn't use their name, even though you didn't use their initials, you're referencing something that could be linked to the student. So it's something to be very mindful of, that if somebody in the community, a reasonable person who does not have knowledge of the relevant circumstances, might be linked to that comment, and even if it's not with a name and initials, etc. Last one on this bullet point: information requested by a person who the educational agency reasonably believes knows the identity of the student to whom the education relates. So, if we reasonably believe that we know the information is related to a student, even if we don't know necessarily it's exactly their name, it would be considered personally identifiable information. All right, next. So we're just getting through some of the basics parts as we ramp up our instruction here. We're not, when is consent not required for having a parent consent? Um, so meaning to provide records. So directory information, we're going to define that a little bit here again in a second. Two things I want to emphasize: school officials with legitimate educational interest. We don't necessarily have to provide consent, or excuse me, have consent to disclose those. And also when we have a judicial order or lawfully issued subpoena or for a health and safety emergency. We're going to come back to a couple of these in a little bit more detail. Um, in the last few days, hearing about ICE and immigration requesting or coming into buildings, requesting students, requesting student files or anything of that nature. There's information about a judicial order or a lawfully issued subpoena. I want to be very clear, some of the information I've read out there about immigration officials, for example, says that we have to have a judicial order only. That's not what FERPA says. FERPA says judicial order or a lawfully issued subpoena. And so immigration officials, ICE, are considered law enforcement. If they have a judicial order or lawfully issued subpoena, we'll have to look at that, very fact specific, and decide whether it's appropriate to give over student information. So there's a lot of that worry and anxiety, but let's just take it case by case and take a deep breath. I'm going to go into a little bit more about these other exceptions when we do not need the parent consent to disclose information. I'll talk about directory information. I'll talk about health and safety, and I'll talk about legitimate educational interest. We'll go to the next. All right, example here, just to have you maybe take a mental break and think about, a yearbook, for example. I've said, personally identifiable information. So a yearbook has name and has photo. That's personally identifiable information. Is that considered protected, that we need parent consent? I want you to ponder that as we go into a couple more explanations. We'll go to the next. All right, releasing records to parents. Again, maybe in your specific role, we've got about 30 of you on today. Let's get into the mechanics and the procedures and the protocols. If a parent is the one requesting information, then they must be given the opportunity to inspect and review the student's educational record. Again, I'm going to just say it a number of times today. I'm hoping that you all come away with some information today that's helpful and a few nuggets of information. One of those being the right to records from a parent is for the right to inspect and review. It's not necessarily for a copy. Many school districts go ahead and provide a copy, but the law says we are to give them an opportunity to inspect and review. So there are certain cases where we allow a parent to come in, we'll have their record at the front office, and then they inspect and review it. And sometimes I've had school districts, that actually deny a copy because, hey, you got your opportunity to inspect and review. Logically and sort of practically, giving a copy or even, potentially charging for a copy is something that some schools go ahead and do. But just keep in mind that the inspect and review is the requirement under the law, not necessarily a copy. And I know we really get a lot of emails. You get a lot of pressure from parents, but take a deep breath. You have 45 days after a request is made. 45 days, that would be calendar days, to to respond on educational record request. I know many times we feel the need to respond tomorrow, but I just encourage you to kind of sit back and understand that you have time to respond to a parent request for records. Another really kind of, again, nerdy on my part, element of parent requests, non-custodial parents. Well, a non-custodial parent is also allowed even though they may not have power to have custody, they're allowed to have copies of educational records. That's often a mistake, I think, that we make. So unless the court has issued an order and specifically stated that they cannot have the record, and that's pretty rare. It's pretty rare. So even non-custodial parents can have a copy of the record. Anytime I get a custody order for a school that I'm asked to review, we look to see if that language is there, that they've been restricted. Many times it's not. I mean, I think maybe once a year, maybe there's one I get. So just keep in mind that that's pretty rare. Non-custodial parents are allowed to have copies. I'm going a little bit fast. So again, if you'd like to ask something in the chat, please feel free. School officials. This is where, how do we know in the education environment who can have access to, I've understood before maybe some tension and some disagreements, maybe even between the administration and teachers, or teachers and their instructional assistants, or teachers in the counseling department about who can have access to the record. So in the school, a school official who has legitimate educational interest in the record. Well, what does that mean? Let's go to the next one, Amanda. That means that you're a school official, meaning it could be your school attorney. It could mean somebody who's under the direct control of the school is a school official, is the short version. Instructional assistant, bus driver, that might be considered certainly a school official. However, keep in mind that you're only to give access to those records in which they have a legitimate educational interest. So, for example, if an instructional assistant needs to see the IEP, then you show them the IEP to do their job. It doesn't necessarily mean the instructional assistant gets full access to all of the records in the student's file. So, parsing out and filtering and separating the concept of who gets access to an educational record is based on what their legitimate educational interest. Often get this question from a school board, for example, like a school board member wants to go look at a student file. That's really not, I would have a tough time, saying that they have a legitimate educational interest for a school board member to review the file. So, that's a difficult conversation to have for a school board member and telling them, but that's the law. All right, I see, Amy, you posted regarding the non-custodial parents access to records. What if there is a protective order against the non-custodial parent that includes the school? Great question. Thank you for that. So a protective order only keeps the non-custodial parent away from the student at home, at school, out in the public. And it's basically a, no trespass against a parent from being around the student. It does not necessarily restrict their access to records. Now, if we have a concern, I've done this many times, that non-custodial parent poses a safety risk, then I would be okay denying that. Oh, and certainly checking with your administration, checking with your school attorney. But for the most part, if a non-custodial parent, even if they have a protective order, unless the order specifically limits and denies them access to records, they would be able to have access to records. Let me give you an example where I've denied that before. When we had a concern about a non-custodial parent and they did have a protective order against them, and there was a concern of them getting access to the record and finding where mom had moved to and getting their address, we just simply didn't give it to them because we felt there was a safety concern. And I think I would certainly defend you and argue that on your behalf. But I'm giving a little bit of a long-winded answer, and the short answer is, unless it's specifically ordered in the order, they still would have access to the records. All right, next. All right, this came up even yesterday. When we have a disclosure to another school district because the student is seeking to and intends to enroll or is already enrolled, we are supposed to be able to send records between school. The sending school may make disclosures if it has included that in your annual notification. So there's an annual notification, which we put out there about directory information and who we can publish your honor roll and everything else. So usually in that disclosure annually, we say that another school that you're enrolling in can get your record without having to have parent consent. So that comes up a lot. Like sometimes the sending school doesn't realize that, and the receiving school is trying to get the record. So just keep in mind that sort of cooperation between schools exception. Next. Directory information. So this is what I was referring to. This is what I was referring to in terms of the directory information, that yearbook photo. So a student's name, some examples there, their major, dates of attendance, all those things. And I think that those examples of directory information are exempted from what we can disclose without parent consent. So yes, these can be disclosed to outside organizations without parents' prior written consent. Like when we have weight and height of members of athletic teams, when we have participation in sports activities, all these things are discretionary on the part of the school in terms of disclosing without consent. Doesn't mean you have to, it means you can. All right, next. I already mentioned this a little bit. Oh, sorry, there was one more slide I missed here on directory information. Schools may disclose directory information without consent. And I think I said that a moment ago, but they can, but they don't have to. All right, next. Court order subpoena. And I think I made this mention already, but required to make reasonable effort to notify the parent or eligible student of the order or subpoena. And meaning when we get that subpoena, we're supposed to then be able to notify the parent, unless the court has told us that that's supposed to remain confidential. So getting a court order or subpoena from a third party, from even law enforcement, we're supposed to notify the parent that we got that court order or subpoena. It's to allow the parent the opportunity to object or to go to the court and ask for that subpoena to be disregarded. And so that's the reason we're supposed to notify the parent. We give a reasonable time and say, hey, we got a subpoena. We're going to disclose those records in 3 days unless we hear from you. Okay, next. Child welfare agency. So this is when, though, there's a child welfare agency, excuse me, that's legally responsible for the care and protection of the student. So if we've got a DCS situation where somebody's taken over for the legal responsibility for the care and protection of the student, we are allowed to disclose student record without parent consent because they've taken over responsibility. DCS will sometimes come in for a child interview and they have exigent circumstances. I didn't necessarily go into that here, but some of you that are counselors, again, or administrators, if a DCS worker doesn't yet have custody, hasn't taken them under DCS custody, just wants to come in and do an interview, there is something called exigent circumstances. And exigent circumstances means that they have a concern about the parent abusing the student or have a safety concern about the parent or the student at home. And so they want to be able to do an interview. And so with exigent circumstances, you might fill that in or write that in your notes because I didn't use that term here in the slides. But with exigent circumstances, they can have access to the student. They just have to let us know that they have exigent circumstances. Thank you, Amanda, for keeping me going here. All right, juvenile justice agencies. This is a defined sort of again, nuanced about what a juvenile justice agency is, and that we can disclose educational records to a juvenile justice agency. So let's, and this is before they're being adjudicated. Let me show you what juvenile justice agency is defined as in the next slide. So it's those agencies that are there for the prevention or reduction of juvenile delinquency. So it could be the probation department, it could be the juvenile prosecutor. This is all somebody that we're working with in juvenile justice because of a delinquency, because of an issue. And it's, um, helps protect the student, helps protect against child abuse, but helping kind of look at juvenile justice agencies and making sure we know that yes, they fall under this exception. Sometimes we get a subpoena or order from law enforcement, but other times we might have a probation office or juvenile justice agent reaching out for student records, and those are allowed to be disclosed. That kind of goes to our next point. Situations. So let's say we have a school shooting, God forbid, and hopefully that never happens. But if there was an emergency, a bomb threat, or a student's life is in danger for some reason, or something of this emergency nature, if we have a health or safety issue, we can disclose records based on a health and safety reason. We're supposed to kind of make note of that, keep record of that. It's not absolutely certainty that it's required, but it's based on the circumstances. And the United States Department of Education, who helps enforce FERPA, has told us that they will not substitute its judgment, their judgment, for that of the school in evaluating whether something is an emergency. So this is exception. It's rare, and you should make note that it is rare, but we do sometimes use emergencies because of a health or safety reason of a student or other individuals. Does that make sense? I'm asking that as like you can reply, but if you have a question about that, please just put it in the chat. All right.
Andrew, there was a question in the chat. I just wanted to make you aware of that in case you wanted to answer before you move on.
Yeah, if there is a judicial order or lawfully issued subpoena and we notify the parents, is there an expected timeline we need to provide the information within, like 45 days? Yeah, I know I mentioned it briefly. I'm probably talking too fast. So it's a reasonable timeline. Normally, what I do if I'm involved or helping a school, um, I will send that to the parent and say, hey, 5 days or 7 days. Um, the 45 days probably that could work. I mean, that could work. I mean, it's probably a little longer than what I would normally use, but if it's a judicial order or subpoena, there's normally a 30-day turnaround. And but it's supposed to be a reasonable timeline that we've given the parent to object before we respond or before we actually issue the records. Hope that helps. The second slide on the health and safety emergency simply clarified a little bit what I've already said, which is the law enforcement agent or whoever it is asking will have immediate access and obtain copies of records that may contain protected information. And then we're supposed to keep a written description of that to note for our records that we disclose under health and safety. All right, I'm going to take a quick pause as I flip my own hard copy here. All right, just a couple of these are just, I don't want to be a rain cloud in describing sort of the penalties, but it is a class A misdemeanor for knowing or intentional disclosure of information that is classified as confidential. And the next one does say that there is some protection as if there is a disclosure from liability, if it's a error on our part, we didn't do it intentionally, then there is some protection under the law if a disclosure was done by mistake or in error. Okay. Let's go to our FAQ section and we'll get into a little questions. And I certainly will ask if anybody wants um, to respond on chat, or Amanda, are they able to take themselves off mute if they wanted to answer? I can't remember.
I think they should be able to, yes.
Well,
But if I'm wrong, let me know. You should be able to.
no worries. So we will, I'll do a couple of just slow down and pause here. Okay, are counselor records, education records under FERPA? Well, it depends. Let's go to the next one. Next one, sorry. Counselor records that are not educational records are those that would, as we talked about earlier, that would be kept in the sole possession of the maker, are not considered educational records. Let's do a hypothetical maybe in the next slide to kind of see if we can illustrate this. All right. Everybody take out your thinking caps and you're ready to chat on the chat or however you want to respond. Parent and parent A and parent B are in a custody battle with a student that you regularly meet with. One day you have parent A calls and demands you send him, the dad, I guess, all your records regarding the student, even your notes. And he reminds you he's entitled to them because he's the father. How do you respond? Before we go forward, think about that. Well, let's see. Here's a couple of things we should have learned already this morning. Let's go to the next slide, Amanda. First, do you have sole access? If you do, then they're not under FERPA and you're not going to have to release them. Again, I don't want you to get in an argument with a father on the phone or your administration, but that distinction, if you've kept them and they've not been exchanged with others, then they're not under FERPA. Did you save your notes on the network with others and had the other people have access to them? Well, then you've probably exchanged them in the technology sense, virtual technology sense, and they would be considered FERPA. So, getting that parent who calls for a counseling student that you have, then, it would be shared and potentially a student record, but not if it's been kept solely for your purposes. Now, in the chat, the question was, what about a Google Doc that has not been shared with anyone else? It's only on your Google Drive. I'm good with that. Again, trying to get into the world of technology in 2025, if that Google Doc has been your sole device, I consider that to be your personal notebook. And so, no, it would not be considered FERPA. Even if it's the school's Google account, Abby, thanks for that question. Even if it's the school owns Google account, I think that it still is your sole possession. I think if other people have access, that's when I think it changes. Okay. Hypothetical that we just asked, but with a twist. Parent A and parent B have a nasty custody battle. Dad's going to ask you for your records, but this time has a subpoena requiring you to provide all records of the student, even your notes. So how do you respond? This is probably our highlight big issue of the day. So everybody pay attention here. So if they have a subpoena and they're asking for all records, not saying education records, they're asking for all records, even broader than what is defined as educational records. So let's go to the next slide. Well, a subpoena, as I just said, is broader, and it may not matter what the FERPA standard would be. Next. But we do have under Indiana law a school counselor privilege. And if you haven't heard about this, hopefully this is the big takeaway for the day. A school counselor is immune from disclosing privileged or confidential communication made to the counselor as a counselor by a student. So the two exceptions to that, if parents right to know, if we have a transition of a transgender student, they have a right to know if their child has been called, wants to be called a different name or pronoun. Or the other exception is anything related to alleged child abuse or neglect. Those would be the two exceptions. But again, maybe this brings up some thoughts and questions about records. If we have a broad request beyond FERPA, we may be able to, you may be able to, or we may be able to, on your behalf, object with the school counselor privilege. Now, again, if something has been disclosed already to other coworkers, we might have a problem there that you've lost the privilege because you've shared it with others. But if there is an opportunity to argue that you've been working with a student, it's been a confidential communication made to the counselor, we might be able to object to disclosing the record. Lots of variables and very fact specific nuances there with that school counselor privilege. But keep it in mind. Let's go to the next slide. Help define a little bit further. The statute does not say who holds the privilege, whether it's the parent or the student. But I think in this day and age of students having some rights, parents also having rights, we're trying to walk that line. And I think we've had situations where a parent might waive the privilege on behalf of a student. I think some of that's going to depend on the age of the student, the maturity of the student, the needs of the student. And so all of those things might come into play with respect to, whether we have to disclose under the school counselor privilege. But let me answer, I think, the question here about does the school counselor privilege extend to a social worker that has a different job title and different license? I'll do a quick double check here in just a second, but I'm almost positive a school counselor privilege, the school counselor privilege is, there's a definition of school counselor. And I think, yes, a social worker might fall into that. Let me do a quick double check to be 100% correct. And I'll do that as we take a pause here in a second. So on that question, does a school counselor privilege extend to a social worker? If it's in the, I think my answer without looking it up is if you're serving in a school counselor role, even if your job title is different, then I think it would apply. But I'll do a double check to see if social worker is also in there as well. Lots of good information there and lots of good questions. So thank you. Let's go to the next one, Amanda. We talked a little bit earlier about emails. I mentioned that in terms of personally identifiable information. And I think that emails have become a little bit of the new dumping ground. Teachers lounge or text messages have as well, where we're kind of going there to vent about students at times. And I think we got to be very careful about that and train your teachers and your staff that yes, emails might be under a student record, even if it's their personal device. So let's go to the next one. How do we do that analysis? Well, if the emails are discussing a specific student, it is with little question that would be directly related to a student. Let's go to the next one. The catch, the word maintain suggests FERPA records would be kept in a filing cabinet. This is where I was talking about sort of, technology hasn't caught up under FERPA. If a school maintains all emails, its records are likely covered by FERPA. So when you get a records request, if there's been dozens and dozens of communication and correspondence on that particular student, it's possible that we're going to have to go back and cull through those to disclose or to have for inspect and review. Remember at the top of the presentation today that I said it's an inspect and review. So yes, if emails have mentioned a student or text messages even, we would have to produce those for inspection and review. I think, again, caution for all of you to take back. Be careful what you put in an email or text because it might have to be disclosed. All right. What can be released and to whom under the health and safety exception? I did cover this earlier, so there's a little bit of duplication here. What can be released? Let's go to the next one. Well, if there's a bomb threat, if there's a hit list, and we have a health or safety reason, go to the next one. School does not need to absolutely to be absolutely certain that there's an imminent risk before invoking the exception. If there's a rational basis for a health and safety concern, again, we just can't throw it around and use it lightly. But if we have a rational basis for a health or safety reason, then we can release the records. And we do that based on personal observation, doing it by information provided us from other officials. And that's when the health and safety would come into effect. Let's see. To whom can education records be disclosed? Health and safety. Again, it's a reasonable time frame with after the request, and it's made in good faith at the discretion of the school official. Again, I wouldn't use it that often, but it can be done. What can be released is next to DCS. I think we talked about this with respect to child welfare, but we know that FERPA generally prohibits release of personally identifiable information. Under the Child Abuse Prevention Act, requires school employees to notify proper authorities when they know or have suspicion of child abuse. So under DCS reporting, we have the ability to disclose information if we suspect child abuse, and that is an exception under FERPA that you are protected. What can be released to police? Police is the next slide. Law enforcement unconnected to the school has no authority under FERPA. So if you do have a school resource officer in your building, we just need to be mindful of our balancing of their role versus administration's role. And so if we have consent from the parent, if it's directory information, sometimes we'll get a request for law enforcement for the name, address of a student. That would be considered directory information and disclosable. If they have a subpoena or court order, and I think that's just relationship, collaboration, trying to make a SRO or law enforcement officer understand, look, we can help you and we want to work with you, but we have to have the right exception. And one of those would be if you could just get us a subpoena or court order. They are able to do that. And sometimes it's a little extra step, might take them a day or two, but don't feel bashful about having a conversation about, hey, we just need that to cover the file, paper the file, to have a subpoena or court order before we can disclose. Go to the next one. And under the school resource officer, again, I want to point out that just because a school resource officer is in the school, let's make sure that the reason they're having access to the school record, the educational record, is because of a legitimate educational interest, meaning that they're helping administration with school discipline, or that they're helping the administration with an internal investigation. Those would be appropriate reasons for a school resource officer to help a education reason or a school official, not for doing a criminal investigation, not for doing a juvenile delinquency, or not doing an investigation that's outside of the school. So there's that difference of when are they helping in their SRO capacity with administration versus when are they doing something outside of the school. And there's a very murky line there sometimes. But just having that collaboration, having that conversation about, hey, there's a difference and we need a subpoena if it's going to be for something outside of school. All right, next. We have a public access counselor in Indiana. And this kind of just emphasizes what I was kind of talking a little bit about earlier, that when public officials use communication modes like email or text, then those accounts become subject not only to educational records, but also to public records requests. So again, big red flag, big alert, big caution to take back to um, the rest of your staff in your building. Even if it's not an educational record, it might be a public record. And we got to be very careful that if it's not considered an educational record, it's going to be categorized as something, and it might be categorized as a public record, meaning anyone could see the email or anyone could see the text. If it's not a student record, it might be a public record. So next slide. So some may be withheld if they contain confidential information, but emails and text are so ubiquitous, and I'm trying to stumble over that in the past couple of decades that they become the preferred method of communication. And knowing that if we're conducting business over text, over software, over apps, over email, then those might be public records, even beyond student records. Just a big caution there. Okay. I'm staying a little bit ahead of schedule on time. Next one, get a lot of questions, maybe not necessarily for your counseling department, but for others. What can the school disclose from videos? Bus, hallway, surveillance. Okay, let's show this. Video captures fight involving students, employee at Arlington High School. So what, if we've got that on a hallway video, what can we show? Is it an educational record? Well, let's do the analysis. Let's go to the next slide. Is it directly related to the student? So that's our first question. Is the video directly related to the student? And does it depict activity resulting in discipline? Is it used to show a violation of the law, or is it being used for purposes of internal use? And therefore, does it make it a student record? So is the video image maintained by the school? Well, oftentimes it is. If the cameras that we're using have a video, have an image of a student, we're often maintaining it. Maybe not for very long. Some schools only capture videos for a couple of days. But if we're maintaining it and we get an immediate request before that video goes through a destruction period, then yes, it might be a student record. Let's go to the next one. So parents have the right to view, but not necessarily get copies of a video. So the Family Policy Compliance Office at the United States Department of Education says, bottom line, if a school official can use the video, then it might be considered, if we've got it for our internal purposes, then we might be able to show the parent. But again, keep in mind that that's just a showing them, inspect and review. I get the question a lot, what if there's other students on that video? If there's other students on that video, it's a record of multiple students. And I know there's some sensitivities there about not showing other families, a video that has somebody else other than their student. But the federal law tells us that if it's their student and we've captured that video because of a fight, we've captured that video because of an incident, and we're using it and we're maintaining it, then yes, the parent has a right to come in, inspect, and review. So often I don't have a problem with that. I often advise and counsel schools that if you're going to have a video, it's there. And yes, if we maintain it and it's captured a student, then we might need to be able to show that to a parent. The way we do that, we set up the video, we have it available in a conference room. Administration would, allow the parents to come in and inspect and review just like we would with a student record. I know that's kind of controversial and people don't like to do that, but I think there's some nuance there of how we do it. And I think just be sensitive to that parent reviewing it. If we could redact the video, that's what the note talks about. We could redact the video. If we can't do that, I try to get consent of parents of the other students. Invite the parent to view the video in person and do not provide a copy. Okay, I think that's getting close. Oh, so here's a spin. In the hallway fight, what if other students video in the fight on their phone? This has come up in the last couple of years about can we, require or have a policy, and if somebody violates that for videoing, then yes, I think that if we wanted to, we could have a informal procedure or policy saying that video can't be taken by other students, that we have some sort of policy procedure handbook language that says, yes, we require permission of administration for students to take video. There's been some question about that and whether it's a public place, whether students should have a First Amendment right. Not necessarily. And I think having a reasonable rule that says we, monitor the use of video in our hallways and we have only permission of admin is something we can strike a balance on. Does the school have liability for violating FERPA? I mentioned a little bit earlier that potentially, yes, lawsuits, parents, having lawsuits and being upset if FERPA is disclosed, or potential penalties for federal funding. All right, a lot of information. Was kind of double checking here on the side as we wanted the answer to that question. Our office at Church Hill and Antrim has extended the school counselor privilege to a school social worker. So yes, our answer is yes. We believe that the school counselor privilege could extend to a social worker. And so that would give you a thumbs up here on your question. I just thumbed it up. Lots of information. I knew I might get done before 12:15. But Amanda, that's what I have. If anybody has any questions.
That is really helpful information. So thank you again for being with us and sharing all of this with us. I am going to pull up just a couple of slides to close us
Yep,
out.
there's a question as you're doing that. If a school counseling intern records a counseling session with a student as part of their internship for the purposes of clinical supervision, has obtained informed consent from the student, is the video considered a school record? The video remains in the possession of the intern and is only viewed by the intern and the intern's faculty. So I think I'd really need to see what that informed consent looks like, Kelly. Probably not an educational record, but it probably depends on what was in the informed consent to the parent. My initial reaction is that would not be a student record.
Thank you for catching that in the chat. And there may be other questions that come in. I'll just go ahead and share these last few slides, but certainly if you still have a question, please unmute or add it into the chat and we'll get to that. Just wanted to share that our last session in this legal series is March 5th, and we will be having again a guest facilitator to share bullying and abuse reporting. So if you haven't already registered for that, you can click on the link here to register there. If you'd like to fill out a very short evaluation form and get a 1 PGP for attendance during the session, just click on this link here, fill out the evaluation form, and then that PGP should come directly into your email inbox. Finally, I just wanted to share some other upcoming events we have scheduled through March, beginning of March. So any of these of interest, you can just click on the link shown here and it will take you to more information and to registration pages. We just added a 2-day prepare training. So if you've been interested in participating in this will take place 2 days in April at CISC in Indianapolis. So registration is now live for that workshop. And then finally, just some resources and contact information. So thanks for being with us again. Hope to see you back in March. And looking at the chat, I'm not seeing any additional questions.
All right. Well, hopefully, again, everybody took something away and can use something today. Appreciate your participation.
Really great information. Thank you again, Andrew.
Absolutely.
Everybody have a great rest of your day. We'll see you soon.